Hi everyone. If you can believe it or not, we only have 3 weeks left of content left for this semester, so we are kind of rapidly coming to a close. I want to be clear that we have more than 3 weeks left in this semester, right? Because we have a week off for Thanksgiving, we have your final exam, and then during the official final exam schedule, we have your final project due. So we still have about 6 weeks left in total, but only 3 of those weeks will be content weeks. And all 3 of these weeks will be covered on your final exam. Our first content area is diversity. We're also going to talk about teams and we're going to talk about leadership. So we're kind of in the phase of this class where we're thinking about how people work together and how people can use their own KSAOs to influence other people. And this is really critical to organizational behavior because so far we've kind of talked about things as if only individual employees matter. But of course, individual employees go to work and they interact with lots of people every single day. So we're going to transition into this set of content by first talking about diversity, right? What happens when we go to work and we interact with people who come from different walks of life, different backgrounds, have different social identities than we do. And to give you an idea of what we're going to cover this week, we're going to start off by defining diversity and some relevant terms. We often hear this in acronyms like D&I or DEI or IDEA, which is the acronym that we're going to use here. And all of these might seem interchangeable, but they do refer to different constructs and there are different organizational policies that would follow from each of these. So I want to make sure that we understand the difference and that we're clear on how we can separate these things out. Then because this is an HR department, we want to think about legal compliance, right? So really understanding what legal protections exist related to discrimination and what different identities are protected under the law. So we'll spend a lot of our focus there. Then we'll also talk through some different forms of workplace discrimination and evidence that those forms of discrimination are unfortunately alive and well. And then we'll conclude by talking about some different ways that organizations can respond and hopefully create environments that are maybe not fully discrimination free, but at least minimize the risk of discrimination. So again, I want to jump in by sort of defining exactly what we mean when we're talking about diversity, because like I said, there are a lot of terms here that people tend to use interchangeably, but really they refer to something unique. And organizations need to think about all of these different ideas, all of these different constructs, and devise policies and practices related to each of them if they want to create a sort of truly inclusive organization. All right, I'm sure we've all probably seen or heard the acronym DEI to capture important terms in the diversity space. I think this acronym is okay, but I personally like the acronym IDEA more, which I don't think is necessarily really a term that people use, and I may have completely made it up, but I think it more fully captures the important constructs in this space. So I'm going to say these out of order, right? They do still make IDEA if you rearrange them a little bit. But I'm going to say them out of order to start with the terms that we might be the most familiar with, and then move to terms that might be newer or might be a little bit more difficult to disentangle from one another. So our first term here is diversity. And here, I think this is the term that is sort of the most readily apparent. And this really just refers to the composition of the work group. So here we're kind of just interested in demographics. We're interested in kind of counting up who falls into what bucket and thinking about how different our workforce is. So we might be thinking about things like the racial composition of a work group or our workforce as a whole, the gender composition, sexual orientation composition, age composition, or any other social identity that we think is relevant for the workforce. So again, really, this is just about who's represented, right? If we just count everybody up, what kinds of people do we have? Then we have inclusion. And this goes a step beyond diversity. It's not just about ensuring that we have broad representation of different kinds of identities in our workforce, but this is more about actually making sure that people in the organization feel included in all organizational functioning. And that means that everybody has a say in making organizational decisions, everyone feels comfortable participating in meetings, everyone can express themselves, and it doesn't matter what the person's identities are, right? People aren't rejected for their identities, but they're sort of fully included and embraced because of their identities, even if they're different from other people or the majority group. And inclusion means that it's not just certain people have power, certain people are in charge, but decision making is kind of distributed across all people, and people have an opportunity to participate in the organization. This is also a much more psychological construct, right? So inclusion is about how people feel at work. It's not just tallying people up like diversity, but actually asking people how they feel, if they feel valued in the workplace. And here there's a difference between sort of being invited and being welcomed. And diversity kind of invites people into the organization. Inclusion makes sure that they feel welcomed. Then we have equity. And equity is not the same thing as equality, though sometimes people use those terms sort of interchangeably. But here, equality would be giving the exact same resources to every person. And sometimes equality is the most appropriate way to approach something. But sometimes equity goes a step farther in making sure that employees' needs are met. And equity here is about recognizing that certain people may need something that's different to what their colleagues need to be able to perform their job or to be full members of the organization. So for example, if we have a person who uses a wheelchair, they might need certain accommodations to the physical environment to be able to do their job or even just access the building that somebody else wouldn't need. Equality would say, well, we've designed the same physical space and everybody has access to it. Equity would say, this person needs something unique, so let's meet those particular needs. And then finally, we have accessibility, which is about ensuring that people have equal access to work resources. And I think this is kind of tricky to keep separate from the concept of equity. So equity is about making those resources available, right? Giving people resources that they need to be able to do their jobs. But accessibility is about making sure that people can actually use them. So we often think about this in the context of disability, and that could include physical accommodations or modifying the space, but it could also include accommodations in the ways that certain things are done at work. So for example, people might have software that they have sort of generally available to all employees. That software helps people do their job, but for someone who has a visual impairment, they can't use that software in the same way as the rest of their colleagues. So accessibility is about making sure that they have what they need to be able to access the software so that they can use it as a support in doing their job. So hopefully this is clear about how all of these different constructs are different. Diversity, again, is just tallying up who we have. Inclusion is about making people feel welcome, feel like they belong in the workplace. Equity is about recognizing that people have different needs and then meeting those needs. And accessibility is about removing any barriers to accessing different work structures or supports or any resources that people need to do their jobs. So there's one other concept that I want to talk through here up front, and this is kind of a key piece of the definition of diversity that we just gave, which is the idea of social identities, right? So I just defined diversity as the composition of the workforce, and here we're really getting at what social identities are represented within the organization. So I think we also have to understand what a social identity is, or what I mean when I use that term. Social identity is really any meaningful characteristic of someone that we can use to classify them into a particular group. The most common social identities that we think of are probably things like race and sex or gender. If we take race as an example, race is a meaningful construct in our society, and we do tend to classify people according to their racial or ethnic backgrounds into groups such as white, Black, Hispanic, Asian, Middle Eastern, and so on, right? So it's a distinct group. We all have a shared understanding of what that characteristic is. We look at people and we categorize them according to their racial or ethnic background. So that's what makes it a social identity. Now, organizations do tend to focus their attention on race and sex, as I just said, but there are, of course, lots of other social identities that matter as well and that have some protection under the law. So we're also interested in things like gender identity or the internal self-concept that one has, which might be the same or different from their assigned sex. We're also interested in sexual orientation or to whom someone is romantically and sexually attracted. We're also thinking a lot these days about diversity in age because we have a really age diverse workforce in this particular moment. We can also think about things like religion, which is protected under the law. And then finally, we can think about ability status, which refers to whether someone has a disability or not. And again, these are all protected under the law, which is why we're focusing on them. But they're certainly not the only social identities that matter. And sometimes intersections of these identities are important to consider. So for example, the experiences of Black women are not going to be the same as white women or the same experiences as Black men, for example. But we're going to sort of approach this from a legal perspective today and think about each of these social identities kind of in isolation. All right, before we move on from definitions completely, I want to just introduce one more distinction that you may see in your book and you probably will hear in other spaces because it's a way that people differentiate different kinds of diversity. And diversity, of course, is not only about social identities in the way that we've defined it here. That kind of diversity certainly matters and it tends to be more visible, but there's also another kind of diversity that organizations do and should pay attention to. So diversity in terms of social identities is what we tend to call surface level diversity because people view it as sort of only skin deep. I personally don't like this term because I think social identities are really integral to the self-concept, but I'm going to use the terminology because, again, that's what the field uses and that's what your book uses. But then there's this other type of diversity that we haven't really touched on yet, and we call this deep level diversity. Deep level diversity is more about functional diversity. It's about having employees who have different degrees, different areas of expertise, different knowledge, different educational backgrounds, different values, beliefs, and so on. So when we're talking about diversity throughout the lecture today, we are going to focus in on surface level diversity because there are explicit laws related to social identities. And of course, we have prejudice and bias against certain social identities, which is why we have these laws in the first place. But I want us to keep in mind that both forms of diversity matter for organizational success. And in HR functions, we should keep in mind both of these kinds of diversity and recognize that both of them can have positive consequences for, say, how we build teams, how we build our workforce, who's working on a project, and so on. All right, so now that we know what diversity, inclusion, equity, and accessibility are, I also just want to really briefly touch on the benefits and, of course, the challenges related to having a diverse workforce. Now, of course, there are a host of benefits associated with diversity, and what we see across the board is that diverse groups of employees tend to be more creative and come up with more creative solutions than more homogeneous groups. The idea is that people who are diverse have different backgrounds, different experiences, and different ways of thinking about a particular problem that are going to lead to more creative solutions. Diverse groups also provide better customer service, likely because they have a better understanding of their customers, who are, of course, going to be diverse themselves and have lots of different social identities. So if you only have a marketing team or marketing execs who culturally understand a certain segment of the population, they may not know how to market to the whole customer base. Then we also see that organizations that employ more diverse people also perform better in a few ways. So they actually make more money and their stock prices are higher. Then, of course, they also save money by avoiding discrimination lawsuits, which can be very costly in terms of litigation, but also because of backlash from customers. One thing that's interesting is some recent data actually show that this relationship is strengthening over time. So the degree to which organizations perform better when they're more diverse is actually greater now than it was, say, 5 years ago or 10 years ago. And then, of course, we can also think about the benefits for individual employees. And what we see is that employees tend to be more satisfied and more committed when the workforce is more diverse. And that's particularly true for employees with traditionally marginalized identities. However, there are, of course, some really important challenges associated with having a diverse workforce, right? We know that if we sort of put people together who have lots of different social identities, things are not always just going to naturally go smoothly. And some of those challenges include things like prejudice, right? We know that people have negative attitudes towards people with certain social identities, and it's very hard to overcome that. And that's something that we're going to talk a lot about today. And then, of course, we might also see things like fault lines occur because of that prejudice, where we actually might see these fractions happen in our workforce, where maybe members of one group tend to sort of hang out with and talk to each other, and members of a different group tend to hang out with and talk to each other, and they don't do a lot of talking across the groups. For example, if we have a sort of a gender diverse team, it might be the case that all of the women talk to each other and all of the men talk to each other, but they don't spend a lot of time talking across those groups. So when we have those fault lines exist, we see these communication barriers. This can be really detrimental to team functioning, and we'll talk about that when we talk about teams. So this makes it really important for organizations to take proactive steps towards creating inclusion, creating equity, creating accessibility, instead of just inviting in a really diverse workforce and then hoping everything just goes fine on its own. And that's what I want to underscore here by introducing the concept of diversity management. So I really want to underscore that we've traditionally in organizations, in OB, in HR, focused on diversity, meaning organizations most commonly just monitor who's represented in the workforce, and they assume that if they have diversity, they've done everything that they need to do and they can stop there. Unfortunately, though, research shows that simply having a diverse workforce isn't sufficient for capitalizing on the benefits of diversity. So we're not going to see that list of benefits that I just listed, and we're way more likely to run into those challenges if we simply hire a diverse workforce and do nothing else. So the key is that we need to go a step further and use what we call diversity management. Diversity management refers to actively devoting effort to managing a diverse workforce and those potential challenges that come with having a diverse workforce. Or, stated in another way, it means fostering an inclusive work environment that is also equitable and accessible instead of just caring about representation. We need to ensure that people, regardless of their identities, all feel like they can participate in the organization and are included in important processes and can be themselves at work. That's when we're going to see diversity pay off. If we don't invest that effort, then we're way more likely to run into those challenges and, again, not capitalize on the benefits of diversity. All right, so now that we've covered all of the basics, I want to jump into talking about the legal landscape related to diversity. And here we're really going to focus in on legal protections that are aimed at preventing workplace discrimination or mistreatment of people based on their social identities. So to sort of put this lecture in context, prior to the 1960s, it wasn't illegal to discriminate in hiring employees. That means that organizations were essentially allowed to hire whoever they wanted. They could not hire whoever they didn't want, and they were fully permitted to be very explicit in that process. You would see job ads that would say things like, women need not apply to this position. And again, that was perfectly legal in the US. However, there have been some really important pieces of legislation that have implemented protections against employment discrimination. The first of those was the Equal Pay Act in 1963, But the most monumental piece of legislation here, the thing that really reshaped the types of rights that employees have, is the Civil Rights Act of 1964. And it's specifically Title VII of the Civil Rights Act of 1964 that focuses on employment discrimination. Then, in response to the Civil Rights Act being passed, we created the EEOC, or the Equal Employment Opportunity Commission, in 1965. And this is the governmental body that oversees the enforcement of the Civil Rights Act. Then we also have a couple of other pieces of legislation here, like the Age Discrimination in Employment Act, which was passed in 1967, and the Americans with Disabilities Act, which was passed in 1990. Now, one of the things that I want to kind of drive home here is that these are really recent. We're going to dive into what each of these says and sort of high level talk about the protections provided by each of these. But even if we think back to the Equal Pay Act, we're talking 1963, right? So we're talking 60 years ago this was passed. And if we look at our most recent 1990, right, that was the year I was born, right? So this was within my lifetime that we've seen some of these protections passed. And what I want to underscore here is that although we have these protections, it takes some time for them to take hold. It takes some time for us to be able to enforce them. And just because we have these laws on the books definitely does not mean that discrimination doesn't happen in the United States. And in fact, we have hundreds of thousands of claims of workplace discrimination brought forward under these laws every single year. Okay, so we're going to start with this monumental piece of legislation as I've just described it, which is the Civil Rights Act of 1964. Very broadly, the Civil Rights Act of 1964 says that you can't discriminate based on what we call the protected classes. And those protected classes are race, color, which is considered separately, sex, national origin, and religion. And of course, here we're talking about Title VII because that's what prohibits discrimination in an employment context. And I want to sort of clarify exactly what we mean by employment discrimination. That means that you can't refuse to hire somebody, you can't fire somebody, you can't not promote somebody, or otherwise deny them some sort of formal access to employment or some employment resource simply because of those protected classes. It also means that harassment is prohibited under the law, and harassment is more interpersonal. So that would include hostile environment forms of discrimination, right? Someone using racial slurs or something like that would be covered under Title VII. It also includes both intentional and unintentional discrimination. And we use different terms to refer to these different types of discrimination. When we're talking about intentional discrimination, we call that adverse treatment. And when we're talking about unintentional discrimination, or what some people call face-neutral discrimination, we call that adverse impact. And that might not be clear yet what unintentional versus intentional discrimination means, but hopefully through an example, this will become a little bit more clear. So an example of adverse treatment could be asking only women who interview for a position if they have children, using that information in an employment decision such that we evaluate all women who have children negatively because we see them as less loyal to the organization. Meanwhile, we ask none of the men who interview for that position the same question. Adverse impact, on the other hand, is unintentional, and as I've just described it, it's face neutral. And what I mean by that is we treat all employees the same way when it comes to adverse impact, but the result of it is different for different groups. So under the same sort of example, I could ask everybody if they have kids or not, but if I only evaluate the women negatively when they say yes, and I don't evaluate the men negatively if they say yes, that's adverse impact. It's still going to result in women disproportionately not getting the job, but we're still treating everybody the same way. We're asking everybody the same question. Then the only other things I want to add here is that the Civil Rights Act is limited to firms that employ 15 or more individuals for 20 or more weeks per year. So really small employers, or if people are just there for seasonal work or something like that, they are not included in the law. And pregnancy discrimination is explicitly covered under sex discrimination as of 1978. So now I want to dig into adverse impact and how we demonstrate adverse impact, because these cases are very different to bring forward. Adverse treatment, we would have to show that employers intentionally treated people differently in some sort of process, in a hiring process, promotion process, paid them differently, something like that. They knew what they were doing. It was systematic. It was intentional. That is very difficult to bring forward. With adverse impact, we do this using the 4/5 rule. And this is sort of a mathematical principle that we use to show that, again, a decision, an employment decision was made using the same information for all people. They were all asked the same question in that selection procedure, for example. But the outcome of using that process was different for different groups. And I'm going to dig into what I mean by the 4/5 rule on the next slide. So here, this is how we would calculate the 4/5 rule. We want to see the ratio of the outcome for two groups and see if that's 4/5 or 80% or higher. If it's 80% or higher, then we don't have a case for adverse impact. If it's less than 80%, then we do have a case for adverse impact. So I'm going to walk you through an example that might be a little bit tricky, but I think most clearly demonstrates this principle. And then I'll give you an example that might be a little bit easier. So let's say we're hiring people. We had 50 white applicants apply to that position, and we hired 25 of those 50 white applicants. That means we have a selection ratio for our white employees of 0.5 or 50%, right? Then let's say we had 10 Hispanic applicants. We hired 3 of those applicants. That's a selection ratio of 0.3. So here we're interested in the ratio of 0.3 to 0.5, or 30% to 50%. And what we see is that this is 60%, right? So 0.3 out of 0.5 is 60%. Because that falls below 80%, this would be a case of adverse impact. It doesn't seem like Hispanic employees had an equal chance of getting hired as compared to white employees. So I think it's a lot easier to think about this example in the case of compensation. So here what we would do is look at the average or potentially the median salaries, let's say for men and women. If men, the average salary was $100,000, let's say, and for women it was $80,000, that's 80%, right? That meets the 4/5 rule. So although there's a difference, it doesn't meet the legal requirement of indicating adverse impact. But let's say on average men earned $100,000 and women earned $70,000. That would be 70%, right? And that would fall below the 4/5 rule, and that could potentially be evidence of adverse impact. So I know that this is a little bit tricky, but again, adverse impact is unintentional. We're treating all employees in the same way. So in this selection context, we're going to ask them all the same questions. But because of something about those questions, we see that certain people don't have the same chance of advancing through the selection process. We use the 4/5 rule to decide if that difference in one's opportunity to advance through the process meets a legal bar for a potential lawsuit. And if we pass that bar, right, if we say this fails to meet the 4/5 rule, we could move forward with a potential lawsuit, though we'd need lots of other pieces of information here. And if we don't meet or fail to meet the 4/5 rule, if it's 80% or higher, then we would really have no grounds for a lawsuit. All right, so now that we hopefully understand Title VII pretty well, we understand that it protects against formal employment decisions that are discriminatory. It protects against things like harassment or more interpersonal treatment that's discriminatory. It applies to those protected classes that we talked about, and it covers unintentional and intentional discrimination. I want to dig into a point of controversy surrounding Title VII of the Civil Rights Act. And that point of controversy is whether or not Title VII should be interpreted as providing protections for things like gender identity and sexual orientation. So if we go back to the protected classes, Title VII explicitly protects sex. And as we talked about, that was very explicitly expanded to include protections for pregnancy. Sexual harassment also falls under sex discrimination, as a specific form of sex discrimination under the law. But what's been really unclear and, again, even controversial about the protections under Title VII is that it isn't clear exactly how to interpret sex. At the time that the law was written, we certainly didn't use different terms to talk about things like sex and gender identity, and it isn't clear if the law should be interpreted plainly to mean assigned sex or a biological characteristic, or if it should be expanded to include things like gender identity and sexual orientation. So this is something that's been sort of battled out in the courts for some period of time. And there were court cases that really tried to answer this question of whether Title VII applied to sexual orientation and gender identity. And it seemed to really be up to the discretion of the judges in those cases. What I mean by that is that there were cases with basically identical facts that would be ruled in totally different ways, where some judges would say, yes, in this case, this is protected under Title VII, a claim about gender identity, for example. And then in other cases under, again, almost identical circumstances, they would say this isn't covered under Title VII because we should interpret sex plainly to mean biology and gender identity isn't protected. So all of this back and forth in lower courts actually led this issue to matriculate up to the Supreme Court just a few years ago. The ruling was in 2020, so this is very recent. And what the Supreme Court decided in that case, which is the Bostock versus Clayton County case, is that both gender identity and sexual orientation should be interpreted to be protected under the Civil Rights Act, and specifically under the protection for sex. And of course, there might be some questions about how this relates to sex, right? I think thinking about gender identity as an extension of sex makes sense, right? It's a little bit more intuitive, but some folks may not initially understand how sexual orientation would relate to sex and how that should be protected under the law. And I would say that, or at least what the argument is here legally, that I can recapitulate for you, is that people are making a different decision in these cases because of the sex of the person. So for example, if a man is fired because it's found out that he is married to a man, that's a different employment decision than you would make if that employee was a woman, right? If it was a woman married to a man, that would be okay. But if it's a man married to a man, that would be a fireable offense. So because the sex or gender of the person is leading to that employment decision, that's a form of sex discrimination, right? That's what's argued by the courts here. So I would definitely still say that these protections are vulnerable because they're not codified into law, meaning there's no piece of legislation at the federal level that outlaws discrimination on the basis of gender identity or sexual orientation in the workplace. And of course, the Supreme Court could certainly reverse course, and we've seen it do that with other big issues. But at least as of right now, the interpretation is that the Civil Rights Act, and specifically Title VII, extends to protect gender identity and sexual orientation. All right, I think we've well covered the Civil Rights Act at this point, so we can move past that, again, landmark piece of legislation. But we also have other protections that focus more specifically on individual identities. And one of those pieces of protection is the Age Discrimination in Employment Act. It's probably not surprising that this protects against discrimination based on age, but one of the key features that we have to keep in mind for this piece of legislation is that this protects only those employees who are over the age of 40. What that means is that if you are under the age of 40 and you think that you've experienced discrimination based on your age, there is no federal legal protection for you. We do, of course, know from the literature that older employees are the most vulnerable to experiencing discrimination, but we also know that younger employees experience discrimination too, particularly if they are perceived as too young for a particular occupation. So if you have a physician who's 25, a lot of people view that as sort of strange for that particular context because they tend to stereotype doctors to be older. So in that context, we would expect that person to experience some discrimination. Again, that is not legally protected. There are some states like the state of New Jersey who offer protections for age discrimination on the younger end as well. But in the absence of state level legislation, there is no protection available here. So I also want to dig into what the Age Discrimination in Employment Act specifically covers, and it includes age-based harassment. We already talked about what harassment means with the Civil Rights Act. This is all of that interpersonal kind of discrimination. So, for example, if someone makes repeated jokes about someone being too old and out of touch or something like that, that would be a case for age-based harassment. It also protects against retaliation for complaining about or filing a claim alleging age discrimination. Hopefully you know that you are protected against retaliation in these cases, both under the Civil Rights Act and under the Age Discrimination in Employment Act. If you, say, filed a discrimination suit against your employer and then they immediately fired you, that is a violation of the law and you would have legal recourse. And then, of course, this act also prevents against making employment decisions based on stereotypes related to age. One of the most common stereotypes that we have related to age is that there are performance declines with age. And what we do see in the literature is that there are, of course, declines in cognitive functioning, particularly cognitive speed across the lifespan. However, we tend to see the biggest declines in older age, so past retirement age. And we also see that when we look at task performance at work and age, we actually see a small positive correlation there, meaning that task performance goes up with age, right? So older employees outperform younger employees, not by a huge margin, but by a little bit. And the reason why is because of job experience, right? Assuming that somebody has worked in a particular type of job, in a particular type of industry across all or most of their career, they're going to have more experience on average at older ages as compared to people at younger ages. And they can use that job experience to make up for any possible cognitive declines that they might be experiencing. Then the final thing that I want to mention here is that under this particular act, this does cover mandatory retirement ages and does say that in general, mandatory retirement ages are illegal. Now, there are some exceptions. If you can make an argument that age is related to the position and has an impact on public health or safety, then you can still enforce a mandatory retirement age. One example of that is pilots. They are required to retire at the age of 65, and that's primarily due to auditory and visual declines. So because of things like a rapid loss of eyesight past the age of 65, that's a case for it being a public health issue, and that's why they're able to maintain their mandatory retirement ages. Outside of those types of contexts, though, this is not generally permitted. Then we also have our Americans with Disabilities Act, which is the final piece of legislation that we're going to talk about here. You might hear me shorten this as the ADA, just a forewarning. And under the ADA, It defines a disability as a physical or mental impairment that limits one or more major life activity. And then to sort of be granted the rights and privileges of the ADA or protections of the ADA, you have to have a record of the impairment, or you have to be generally regarded as having the impairment. Typically, all that requires is having a note from a physician indicating that you've been diagnosed with some kind of disability, and that would allow you protection under the ADA. Now, there is something unique about the ADA that we haven't talked about with either of our other pieces of legislation, and that's the guarantee that organizations that have more than 15 employees have to make reasonable accommodations for employees with disabilities. Now, there are two kind of caveats that help us understand what reasonable accommodation means. The first caveat is that you don't have to make an accommodation if it would change the essential function of the job. So if there's an essential purpose of that position, something that is directly related to the mission of the organization, the reason that position exists in the first place, you can't ask for an accommodation that doesn't allow you to actually do that function. So you can ask for things that might assist you in fulfilling that function, but you can't be asked for that function to be taken out of the position. Then the other sort of caveat here is that you are not required to make an accommodation if it would create undue hardship for the organization. And the language of undue hardship is not really clear. This is definitely a point of confusion with the ADA, but generally speaking, they consider the cost and sort of nature or scope of the requested accommodation, and then they consider the size and financial performance of the organization. So if we had a case where we had a really small organization that isn't particularly profitable and someone was asking for a very expensive accommodation, that would create an undue hardship and they would not have to grant the accommodation under the law. However, if we have a big firm, something like IBM, and we have an accommodation that might cost a couple $100 or a couple $1,000, the expectation is that you would make that reasonable accommodation, again, provided that the employee can fulfill the essential function of the job. All right, so now that we've talked about all of these legal protections and all of the groups of people who are protected from discrimination in the United States, I also wanted to talk about cases where discrimination is essentially legal or where it's absolutely permitted to hire somebody with a particular social identity or choose not to hire somebody with a particular social identity. And the case in which discrimination is permitted, where we can say that membership of a group is a necessary condition for employment, is when we can argue that having membership in that particular group is a BFOQ, or a bona fide occupational qualification. And essentially this means that there's something about the job that can legitimately only be fulfilled by a certain kind of person, a person with a certain kind of identity. Now, an example of this is if you're hiring an attendant for a women's bathroom, you could reasonably argue that that person should be a woman. If you have a correctional officer working in a women's prison, you could similarly argue that that should be a woman. When we think about religious institutions, right, Catholic schools, they often require that their employees be Catholic and sort of show proof that they're actively adhering to their faith. That's also allowed under the law because the argument that it's a BFOQ, a bona fide occupational qualification to be able to do that job. Now, this doesn't include preferences. You can't just say, well, we like it when people who do this particular job are women or of a particular group of whatever kind. You have to show that other people could not actually do the job, perform the essential functions of that position. Now, one example that I always like to give because I think it's an interesting example is Hooters. If you've ever been to a Hooters, if you know anything about how Hooters operates, the front of staff at a Hooters is exclusively women, right, or front of house. All of their wait staff are women and women who look a particular way. And of course, this would seem at first blush discriminatory there are a number of men who have sued Hooters for discrimination because they've been denied front of house positions. Some of them have been kind of successful in that they've gotten a little bit of money out of Hooters, and Hooters has had to expand their back of house positions and hire more men into back of house positions. But Hooters has been able to maintain an all-woman waitstaff front of house hiring model for the entire existence of Hooters as a company. And the reason why is because they argue that they are not primarily a restaurant. That's not the essential function or mission of their organization. Instead, their essential function or mission is to provide entertainment. And in order to provide the experience that they aim to provide to their clientele, they have to have women in those waitstaff positions. And again, they've been legally successful at making this argument and arguing that it is a BFOQ, a bona fide occupational qualification, to be a woman to work in the front of house at Hooters. All right, so now we're going to jump into talking about evidence that workplace discrimination still exists, even though we have these pieces of legislation that we've just talked about. As I said up front, these are all still relatively new. The Civil Rights Act was only passed 60 years ago, and it takes time for these things to take hold. And even in the case where we have laws, we know that people violate the law and discrimination still occurs. As I stated, we have hundreds of thousands of cases of discrimination that are brought forward in the United States every single year. So we're going to talk about evidence of that discrimination in some different domains. But I'm going to start off by defining some terms that I think are helpful to keep in mind here as we think about exactly what discrimination or bias is. So first, I'm going to define bias. And bias, the formal definition here, is a negative attitude about people belonging to a certain group. And here, because this is an attitude, we have our ABC model again, which we've already talked about early in the semester when talking about job attitudes. And that means that we have an affective component, or how people feel about the target. We have a behavioral component, or how people behave towards the target, and a cognitive component, or what people think to be true of a particular target. So here, our cognitive component is a stereotype. Stereotypes are everything we believe to be true of members of a particular group. Then our affective piece is prejudice. This is how we feel towards members of a particular group, members that have a particular social identity. And then discrimination is our behavioral piece. This is how we actually act when we're interacting with people of that group. And the idea is that this is kind of an unfolding process. This is going to start with stereotypes. We believe that certain things are true. Because we have those beliefs, we're going to feel certain ways when interacting with members of a particular group, and that's going to lead us to behave in different ways with different people. If we have a negative stereotype, we believe members of a group are all dangerous, they're all criminals. That's going to lead us to feel negative, fearful, anxious when we interact with people, and that's going to lead to discriminatory outcomes. Then we also can differentiate between implicit versus explicit bias. And to demonstrate the difference between implicit and explicit bias, I want to introduce a riddle here on the next slide. So our riddle is: a father and his son are in a car accident. The father dies instantly, and the son is taken to the nearest hospital. The doctor comes in and exclaims, "I can't operate on this boy." "Why not?" the nurse asks. "Because he's my son," the doctor responds. So maybe you immediately know the answer to this riddle. Maybe you don't. If you don't know the answer, I would recommend that you pause here, take a second to reflect on what the answer might be. But hopefully, if you've reflected a little bit, you've come up with the correct answer, which is that the doctor is his mom, is the son's mom. And the reason why this riddle is tricky for some of us, right, maybe not all of us, is because when we think of doctor, we have an implicit assumption that the doctor is a man. So because we know this boy's father died, we are just left in a state of confusion about how this could possibly be true. Sometimes people say that the answer to the riddle might be that he has two dads, right? But then we're still assuming that a doctor has to be a man. That's the underlying implicit assumption that we're making here. And this helps us really differentiate implicit bias from explicit bias. Implicit bias is bias that's automatically activated. When we hear doctor, we think man automatically. And it happens outside of our conscious awareness. We're not even aware that we're making that assumption about who a doctor has to be. And that's why the riddle is tricky, because we can't see past that assumption because we don't even know that we're making it. Then explicit bias is bias that we have access to, that we are consciously aware of, we know we feel, we might be willing to admit that to ourselves, to other people, and so on, right? Both of these are really important because they shape our behavior. And what we find is that implicit bias is much harder to change because people don't know that they have this type of bias, but it still drives behavior, right? So this is kind of a really tricky piece in getting rid of discrimination, is how do you get people to be aware of biases that they don't have, and how do you combat bias that people aren't aware of? Okay, so now that we understand bias and some different kinds of bias, I want to jump into summarizing evidence of discrimination or of bias more broadly. And again, I'm going to segment this into different contexts in the workplace. And we're going to start off by thinking about bias in the hiring process. Now, there are a ton of research studies that look at bias in hiring, and they look at that based on lots of different identities. So I want to give you an idea of what sort of the prototypical study looks like here. What they tend to do is construct some resumes for open positions, probably entry-level positions. And what they're going to do is put together two resumes that are absolutely identical in every way. They have exactly the same qualifications. The only difference is they vary something like the name on the resume. For half of the cases, they might put a traditionally feminine name, and half of the cases they might put a traditionally masculine name. And then they're going to send them out to actual open positions in actual companies, or they're going to show them to actual hiring managers and ask people to evaluate whether they would hire that person, whether they would give them an interview, and how much money they would offer them in starting salary. Now, what we see across the board is that there is lots of evidence of hiring bias. If we, again, take that context where we have identical resumes, one has a man's name, one has a woman's name on it, what we'll see is that the equally qualified woman is less likely to get the callback, the interview, and offered lower starting salary as compared to the same resume with a man's name. We see the same thing for race. We see that white applicants are more likely to get that callback as compared to Black applicants, Hispanic applicants, Middle Eastern applicants, and Asian applicants. And in fact, those differences have not changed across time. So there are some analyses looking at whether that bias has shrunk over time. And they've found that over several decades of time, the racial bias is identical in terms of how big that bias is. We see the same thing for gender identity in that transgender and non-binary employees are less likely to get the callback. Age discrimination also seems to happen in the hiring context, where we tend to see older applicants get fewer callbacks in general, but we do see younger applicants not get callbacks if the occupation is stereotyped to be older in age. Employees with disabilities are less likely to get the callback, and employees of different religious minorities, so Jewish employees, Muslim employees, and agnostic or atheist employees are less likely to get callbacks as compared to Christian employees. Then we also have discrimination in the context of wages and how much people are paid in the workplace. And of course, there's some controversies surrounding the wage gap and exactly how to look at it, and some people argue that the wage gap doesn't exist, and right, there's lots of dialogue around here. So I want to be really clear about what we're talking about when we're talking about the wage gap. We're talking about the annual median salary for full-time employees in the United States, and we're looking at that annual median salary for women as compared to men. So if we look at this, we see that in 2018, women earned roughly 81% of what men earned. So that's the wage gap that we're talking about. And then we also see that these numbers have not really meaningfully shifted over time. So obviously we're in 2024, we're talking about numbers in 2018. That wage gap has not shrunk in any significant way since 2018. And we actually haven't seen a lot of progress really in the last decade or two on closing the wage gap between men and women. We also have projections that based on the current progress towards closing that wage gap, the wage gap won't fully disappear until 2059. And then this is also a bit intersectional in that women of color make less overall as compared to white women, or the wage gap is larger for women of color as compared to white women is another way of framing this. So if we compare the average median salary for white men as compared to Latinx women and Black women, we see that Latinx women make about 68% of what white men make, and Black women make about 72% of what white men make. So again, that's a bigger gap than the 81% overall. Then we also have lots of evidence demonstrating that there's bias in promotions and leadership. And a lot of this is because there's also an implicit bias that we have seen across lots of different countries and lots of different data collections, where when we think manager, we think male, right? When we think of people who are leaders, we sort of imbue them automatically with masculine characteristics, and we therefore think that men are better suited for leadership positions as compared to women. And we certainly see this bear out in the data, right? And there are biases, of course, beyond gender as well. But if we sort of take stock of who is in high-level C-suite positions within Fortune 500 companies, we see that only 20 of the 500 companies have CEOs who are Hispanic, only 5 CEOs are Black, only 30% of directors are women, and only 21% of directors are from minoritized racial groups as a whole. So lots of evidence that people of color and women are very underrepresented in these high-level leadership positions. And of course, we tend to focus in on the bias that women experience in promotions and leadership in particular. And this is actually so pronounced, right? The bias against women in these positions is so pronounced that we've come up with some different metaphors that we use to describe the different biases that women experience. The first is the glass ceiling, which I'm sure you've all heard of. This is where women are less likely to get promoted into high-level leadership positions. So in other words, there's this invisible barrier where women are advancing in their careers, they hit that barrier and they can't move forward, right? They can't move up the ladder anymore. Then we also have the sticky floor metaphor, which refers to women being overrepresented in the lowest rungs of leadership. So they're underrepresented at the highest, and they're overrepresented at the lowest. And specifically what we see is that women are overrepresented in what we would consider to sort of be low-level dead-end jobs. So positions that are low salary, positions that are relatively precarious, that don't come with benefits, that have very low salaries. We see women dominate in those positions. Then our final metaphor is what we call the glass escalator, and this refers to the tendency for men working in pink-collar positions or positions that are dominated by women to be promoted at a faster rate as compared to their equally qualified female counterparts. So when women work in male-dominated fields, we tend to see that they're disadvantaged in a number of ways. But when men enter into women-dominated fields, we tend to see that they excel very quickly. Then, of course, there's also some interpersonal discrimination that people can experience. It's not all just in these big formal decisions that people make at work. And we can think about a couple of different forms of interpersonal discrimination here. First, we can think about things like microaggressions, which are defined as brief, commonplace, daily verbal, behavioral, or environmental indignities. So these are potentially minor slights. They don't have to be minor, right? Sometimes microaggressions, we think they have to be subtle. They really don't. But these are just things that happen in everyday interactions. They might be brief interactions. They might happen sort of quickly. But these are things that happen so frequently as to be generally accepted as normative behavior. Then we also have sexual harassment, and under the law, we differentiate between two forms of sexual harassment. The first is hostile work environment, and the second is quid pro quo harassment. Hostile work environment refers to sort of ambient signals of sexual harassment. So that could be people making explicit sexual jokes, people making inappropriate sexual comments. It could be people displaying sort of pornographic materials in the workplace, which seems like something people don't do, but that is absolutely something that happens. Anything that creates an environment that's uncomfortable and that has these ambient signals of sexual harassment. Then we have quid pro quo sexual harassment. Quid pro quo means this for that. And this is where you try to exchange some sort of job-related resource or consideration for sexual cooperation. So if someone says, I will only give you a promotion if you go out with me, if you kiss me, if you do something further than that, that would be an example of quid pro quo sexual harassment. Okay, so now that we know that discrimination is, again, unfortunately alive and well in organizations, and we know that it's affecting people in lots of different contexts, let's very quickly talk about what we can do to manage diversity. Now, the most common thing that organizations do is have an affirmative action plan. And here I would traditionally ask students what affirmative action is, because there are a lot of narratives around affirmative action that aren't accurate. There's a lot of misinformation about affirmative action. But what affirmative action actually is just a plan that helps employers identify areas where certain groups of people are underutilized in the workplace. This is primarily done through what's called a utilization analysis, and this involves simply monitoring the demographics of the labor market, then monitoring the demographics of who ends up in the organization. If there's a significant difference, right, going back to that 4/5 rule in adverse impact, if we see evidence of adverse impact, then the organization would take corrective action. And if we don't see evidence of adverse impact, then we wouldn't do anything at all, right? We would continue our organizational practices as we've used, or as they've been used in the past. Now, here, under affirmative action, if we're finding evidence of a discrepancy between our labor market and who we're hiring into our organization, we would call that underutilization. And if we have underutilization, meaning maybe we have a ton of, let's say, women applicants applying to our job, but we're not hiring them into the job, or we're not retaining them, so our workforce doesn't show that women are well represented, that underutilization, we would take some kind of action to fix that, right? So we would come up with a targeted plan to fix an identified problem. That action could be as simple as targeted recruiting. It could be that we're intentionally trying to recruit from sources that would increase the number of women who end up in our applicant pool, who end up getting hired, and who end up staying in our organization. That might also be a specialized training program. So we might find that there's one particular skill gap that's preventing women from being hired into our workforce. We might just decide to stop selecting based on that and rather train based on that and improve the number of women that we have. Then we might also do something like have a specialized mentoring program or feedback programs. So if we imagine that we have employees with disabilities, for example, we might need to gather feedback from those employees more frequently than other employees to make sure that they've received adequate accommodations and that those accommodations are doing what they were intended to do, or if they need something else, right? So that's what a specialized feedback program or specialized mentoring program might do. So a lot of people tend to think that affirmative action plans involve setting up quotas of some kind, or reserving or earmarking jobs for people of particular backgrounds. And I want to be really clear that that simply isn't true. And in fact, that is expressly illegal. So you cannot set quotas for particular people in particular positions. And affirmative action also doesn't mean that we change our hiring standards for people, right? It doesn't mean that we hire people who are unqualified simply because they have a particular identity. It simply means that we monitor for legal compliance. If we see that we aren't complying with the law, we try to take some sort of corrective action to get more people from certain groups that are not well represented in our workforce into our workforce. All right, so we, of course, can do more than just have an affirmative action plan. Again, affirmative action plans are really just about monitoring, and they don't often go farther than that. So I gave you some options of other things that people or organizations could do. They tend to just stop at the monitoring piece. But one thing that is common that goes a step beyond affirmative action programs is what we call diversity training. Now, the first point I want to make here is that diversity training is very common, and it's something that organizations spend a lot of time and money on. There's the cost of the training itself, the cost of potentially paying for facilitators of that training, the cost of lost work time because people are in training, which can sometimes be pretty lengthy and pretty costly. And sometimes there are other costs as well, like paying for things like post-training assessments. So it's probably not surprising that organizations spend a ton of money on diversity training every single year. And in fact, some estimates show that US companies spend upwards of $8 billion a year on diversity training efforts. And if we focus in on just the Fortune 1000 companies, they spend an average of $1.5 million a year on diversity training. Then to give you just one example, there was this incident that occurred. It was a racist incident in a Starbucks in Pennsylvania a few years ago, at this point, maybe 5 or 6 years ago. And essentially a Starbucks employee called the police on 2 Black customers who had stayed too long in the store, even though they don't enforce that rule for any other customer that came into the store. The incident got a lot of media attention. Starbucks got a lot of flack in response. So what Starbucks decided to do was close all of their locations for a company-wide diversity training effort. And in total, that decision cost them $12 million just in lost profit for a 1-day training. And that's, of course, in addition to whatever they spent on the training itself. So with price tags this hefty, I think we want to know whether diversity training is worth that money, whether diversity training actually works. And the answer is kind of lackluster, to be honest. So diversity training programs are any training program that aims to reduce bias and discrimination. And there have been some big, large-scale meta-analyses trying to look at whether diversity training programs actually work, whether they produce the types of outcomes that they're intended to produce. And what those meta-analyses have shown is that they do tend to improve knowledge. So people are better at defining sexual harassment, better at sort of, understanding the law, better at understanding prejudice and the content of stereotypes and those sorts of things. But we don't really see that that translates into changes in other types of things that we probably care more about. So we don't really see that diversity training changes attitudes, and it doesn't really seem to change behaviors. So it's not reducing the stereotypes that we have, and it's not reducing discrimination. And we also see that these effects are not very sticky, meaning they don't last for a very long time. So we might see a little bit of a change in an attitude or a behavior up front, but if we think about this 3 months later, 6 months later, a year later, people aren't really keeping up with those changes. Those changes are going to disappear. So what I want to say here is that this is not a case for getting rid of diversity training. This is a case for making diversity training better. Lots of training doesn't work. So this is not unique to diversity training. When we've sort of talked about training broadly, there's lots of issues with transferring training onto the job. There are lots of ways that training fails. Again, this doesn't look different if we were doing leadership training or skills-based training or something other than diversity training. And also, we tend to see that organizations offer training one time for an hour or an afternoon or during lunch or something like that. And then they change absolutely nothing about how they do the job. They don't encourage transfer in any sort of way. They don't tell people that they should use what they learned in training on the job. If that's our approach to diversity training, of course it's not going to work, in the same way that no other training is going to work under those conditions. When we integrate diversity training into a comprehensive plan for DEI within our organizations, we see that it can be very effective. And we see that other forms of DEI programs, policies, practices are very effective at improving things like inclusion and equity and accessibility and reducing performance decrements among different groups and those sorts of things. So I don't want to say that we should throw diversity training completely out the window. The key is we have to be thoughtful about it, we have to design it in the right way, and we have to make it part of an integrative approach to implementing DEI at work.